participate
Monday.
For direction.
Direction.
You have granted the interim order of suspension stay, my lord. Even today, the respondent authority is not taken back.
Good. Next week.
One matter, my lord, suspension matter only, my lord. There is no interim order, but the period of suspension is 6 months is already over. My lord.
Over.
Deemed revocation.
Revocation access.
Tomorrow, my lord.
Revocation and tagidiya. The complainant there.
If he is the complainant and matter has been seized, the same issue, lordship. Same public road.
Next week.
Have it tomorrow, lordship. Some urgency is there. Injunction order is passed yesterday, lordship.
Next.
Monday.
With my lordship's permission, my lord, serial number 20. That issue is, my lord, pending before the Honorable Apex Court. Didn't matter, my lord. So it can be had after vacation.
All. 20. Post after vacation as requested by the counsel for the panel counsel for the revenue, who says that identical matter is being considered by the Apex Court.
Much.
Okay.
My lord, serial number 16, my lords.
16.
16, my lords.
Again.
Lords, we have to produce certain documents, my lords, regarding certain rules. Like request after vacation, my lords.
All after vacation at the request of.
Yes, my lord.
For facilitating production of certain documents.
Yes, my lord.
Yes.
For order seal number 1, Tanmati,
Appear, sir, apparently.
1H.
I have filed a memo, my lord, for dismissal.
You want to?
That pursuant to the Leonard single judge's order,
Ah.
that they have issued me refund, accepting the refund orders. I have filed that order before your lordship.
You have accepted that.
Lord, I was to get around 8 crore refund. That during the pendency, my lord, there is an interim order which was passed, directing the respondents to process the application under the scheme. So they processed it, resulting in refund of around 3 crores. Lord, this was
Under
brought
that
to-
scheme.
Under this scheme, second prayer, alternative prayer.
Yeah.
The writ petition was disposed of, taking note of the fact that the application under the scheme has already been accepted. So question of considering the first prayer would not arise. So my learned friend filed an application, writ appeal before this honorable court, questioning the order of the learned single judge. Lord, in pursuant to Lord accepting the learned single judge's order, they have issued me refund now.
No, where was the option to them?
If refund could be kitto.
That's all right. Where is the option? Suppose if decree is passed and the judgment letter complies with the decree, do you mean to say right of appeal withers away? No.
Agala, Lord. Under the scheme, which is an alternative prayer,
But that was,
revenue is benefited out of
but
it.
they had rejected it. You challenged it by way of
They did
interim order.
not reject, they said, we will not process your application.
That's rejection only. This is like calling half a dozen as a 6. So effect is same.
End
Now
of the day.
pursuant to order they have done it. Then they are entitled to challenge it. Therefore, let it come after vacation.
Allah, refund could be there. There is nothing now. Survives.
No, how can you? Stay continue, madam, please. Await service, interim order to continue. Police notice mukantrano hogilva?
No, they wait in
Yes. please. Huh.
seal number 3, Mithun J.
For the petitioner, your lordship.
For number 7/125 tala, 1 second. Second one. ಅದರಲ್ಲಿ 7/125 ಇಂದನೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ವಾ ನೋಡ್ರಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಎಸ್
Seal number 3, Mithun J.
ಮಿಥುನ್ ಏನಿದು
Your lordship, the amendment has been carried.
You have carried out?
Yes. And the petition has also been placed, your lordship.
On
On
filing of amended petition.
ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್ ಒಂದು
we
ಹಾಕಿ
have also placed it on 7th March 2025.
you have filed it already counsel for the
Not,
petitioner
sir.
submits.
Amendment petition has not been provided, my lords.
ಕೊಡಿ ಕಾಪಿ ಕೊಡಿ ಪ್ಲೀಸ್ ಇದೆಯಾ petitioner's counsel submits, amendment is carried out and amended petition is also filed. First off,
Placed on.
this the registry has to verify. First off, he further assures that a copy of the amended petition along with all the documents shall be handed to counsel appearing for the respondents and file affidavit, file a compliance report in the registry within 1 week, failing which amended the petition stands rejected.
Number 5, K.R. Krishnamurthy.
Petitioner, my lords.
Compliance ಮಾಡಬೇಕಲ್ಲ.
My lords, it's complaint, my lord. He had taken out hand summons and the acknowledgement is already filed on 24/2/25, my lords.
You have taken hands, you are permitted to take hand summons.
Yes, yes, my lords.
This court wide
The last occasion, they were called out also.
ಆಲ್ ಔಟ್ ಆಗಿದೆ, ಸರ್ವಿಸ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿಲ್ಲ ಅಂತಾರ.
Yes.
Has been served ಆಯ್ತಲ್ಲ. Service listing the respondents held in view of personal service permitted by 24/2.
Pass over, my lords, on his legs. His argument.
Is he on his leg or on his feet? Which is issues
On his feet, my lord.
feet. Sometimes leg is also used. ಏನ್ ಬೇಕಾದ್ರೆ? Model will continue.
My lord,
Year number 63 would be granted, subject to the arguing the matter today, because server complaint, I have taken notice even for the other respondents who are there in that matter. Kindly hear two petitions who are there, 63 and 63.3. And 6.3. And these two petitions relate to appointment of the arbitrator. Other two petitions relates to allowing of the amendment application by majority. Both the orders are of majority. Kindly notice, we have an urgency in the matter. And that's the reason I made a request over there even on the last date of hearing.
ಯಾವಾಗ expire ಆಗ್ತದೆ ಇದು mandate?
Mandate's already been expired. It's expired in 2020 itself, to 2023 itself.
Not recommendation.
But my lords, the question would be, my lord, the problem is that it's a huge apartment complex that has been built and the entire our area has been held as a lien by them. And none of the area commercial spaces are being sold and that has not even been utilized. And an order passed by the arbitral tribunal for selling of the residential apartments, this writ petition came to be filed. And therefore, we are not even able to reap even the bare minimum fruits over there of the property. And kindly notice, because we have given them the 23 acres of land for development. And we are not even able to put that property into any other use even because they have hold it as lien. And whether its lien is right or wrong is a question that required to be decided by the tribunal. And then whether this apartments it's disproportionate even with respect to their claim. Their claim is only with respect to money. And this is virtually around 170 crore in excess of this thing.
June working.
170 crore in excess of this thing.
June working, na?
Lord, sir, you would
End of
request.
June is working.
I understand this, my lord. I will file the wakalat today.
6.3.
6.3.
I will file the wakalat today.
6.3.
6.3.
My kind.
Seal number 7, Nandesh Devakar.
Appearing for the petitioner, my
Yes,
lord.
Nandesh ಏನಿದೆ?
My lords, there are three office objection raised, my lords. One and two pertain to rule 2 sub-rule 3 and 2 sub-rule 3 sub-rule A, my lords. That has been complied with, my lords, already.
ಸರ್ವಿಸ್ ಮಾಡಿದ್ದ?
Illa, my lords, this is pertaining to mentioning that alternative remedy is not.
Okay.
Adu mention ಮಾಡಿದ್ದೀನಿ petition ಅಲ್ಲಿ, on page number 12 it has been mentioned, my lord. The other office objection pertains to me not filing the petition in 2 copies, my lord. That I will comply with today. Kindly a date may be fixed, my lords.
ಯಾವತ್ತು ಕಂಪ್ಲೈ ಮಾಡ್ತೀರಾ ಅವತ್ತು ಬಂದ್ಬಿಡತ್ತೆ.
ಇವತ್ತೇ ಕಂಪ್ಲೈ ಮಾಡ್ತೀನಿ ಸರ್.
ಇವತ್ತೇ ಮಾಡ್ತೀರಾ?
ಇವತ್ತೇ ಮಾಡ್ತೀನಿ.
ಇವತ್ತು ಮಾಡಿದ್ರೆ ನಾಳೆ ಬಂದ್ಬಿಡತ್ತೆ.
Great.
First immediately after compliance.
Grateful.
Okay.
Hearing on yes, number 8, Vinayaka Kamath, Sachin BS.
ವಿನಾಯಕ.
Appearing for petitioner.
ಹಾ.
The mediation process is on.
ಏನು ಅನ್ನು ಏನಾರ ಆಗ್ಬೇಕಲ್ಲ? ಲಾಸ್ಟ್ ಟೈಮ್ ಸೇಮ್ ಸಬ್ಮಿಷನ್.
Yes, Your Honor. ಅದ್ರಲ್ಲೀಗ
ಸೇಮ್ ಸಬ್ಮಿಷನ್.
Yes, Your Honor. ಅದ್ರಲ್ಲೀಗ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಗೆ ಹೋಗಿದೆ, ಬಿಲ್ಡಿಂಗ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಗೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಪರ್ಚೇಸರ್ ಇಸ್ ರೆಡಿ ಟು ಪರ್ಚೇಸ್.
ಅದ್ರಲ್ಲಿ ನಾವು ಹಂಗೆ ಕೋರ್ಟ್ ಕೇಸ್ ಇವು, ದೀಸ್ ಆರ್ ನಾಟ್ ಅಜಿಟೇಷನ್ಸ್, ಚಳುವಳಿಗಳಲ್ಲ ಇವು, ಮೊಕದ್ದಮೆಗಳು.
ಅದಕ್ಕೋಸ್ಕರ ನಾನು ರಜೆ ಇದ್ದದ್ರಿಂದ ನಾನು ನೆಕ್ಸ್ಟ್ ವೀಕಿಗೆ ನಾನು
ಅರ್ಗೆ ಮಾಡಿ.
ಕೈಂಡ್ಲಿ ಪಾಸ್
ಪಾಪ ಹಂಗೆಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಕೈಂಡ್ಲಿ ಪಾಸ್
ಪಾಸ್ವರ್ಡ್ ಕೊಡು, ಅರ್ಗೆ ಮಾಡಿ, ಟೈಮ್ ಕೊಡಲ್ಲ. ಅದೇನು ಟೈಮ್ ಫ್ಲಾಟ್ ಖರೀದಾರಿ ಏನು ಹಂಗೆ ದುಡ್ಡು ಕೊಟ್ಟು ನಿಮ್ಮ ಹತ್ರ ಎಲ್ಲ ಆಮೇಲೆ ಸತ್ಕೋಬೇಕಾನ ಯಾರು? ಯಾ ಪಾಸ್ವರ್ಡ್.
Seal number 9, Jeevan K.
for the petition.
Given. ಏನಿದೆ?
ಅದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ರಿಗಾರ್ಡಿಂಗ್ ದಿ
ಏನ್ ಹೇಳಿ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ನೆನಪಿಲ್ಲ.
ಅದೇ ಅವರು ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್
ಡೆಕ್ಕನ್ ಹೆರಾಲ್ಡ್
ಪ್ರಜಾವಾಣಿದೆ ಹೌದು. ಎಕ್ಸ್ಪೆಲ್ಡ್ ಎಂಪ್ಲಾಯ್ ಅಂತ ಇದ್ದಿದ್ದಕ್ಕೆ ಅವ್ರು ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಆಗಿತ್ತು, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ.
ರಮೇಶ್ ಏನು ಅವ್ರು ಬಂದಂಗೆ ಕಾಣಲ್ವಾ?
ಅಂದಾಗಿ ಬಂದಿಲ್ಲ.
This court wide order dated. So and so had said as under. First, today when the matter was called out, the party in person being the respondent is absent. First off.
That's the same thing, Lord.
Same person.
Same person. That's the same thing, Lord.
Same person.
Same person.
But ಅವರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
I will see and make good, my Lord. Otherwise I'll file a memo.
Office objection to be addressed.
Publish.
The other office objection to be addressed.
Please.
Yes.
Scene number 10, YV Raviraj.
My Lord, against the impugned order, my Lord, a miscellaneous petition came to be filed, which came to be allowed.
So from that date it is counted.
Counted, my Lord, that is a very next matter, my Lord, 110 days. Notice has to be.
Not elderly note, 10 and 11 notice, emergent notice.
Admission matters number 12, Prashant Shigas.
Yes. Yes, Mr. Das,
Challenge, your lordship, is to a order of the tribunal.
power of the tribunal.
Order of the tribunal, your lordship. Also see page 29, your lordship. The questions of law which we have framed. This is under the the GST law. GST law. Whether in the facts and circumstances of the case, the tribunal was right in holding that the appellant is liable to pay interest on the basic excise duty and NCCD when the levy of duty itself was suspended by virtue of the order of the Honorable High. GST has come. The duty, GST was paid on your lordship on the total value, and these are all tobacco products, very high tax is there. The question, your lordship, was after the GST is introduced, can you still continue to levy central excise duty, which is part of the pre-GST law, or the NCCD, National Calamity Contingent Duty, whether you can still continue to do it. So that's a challenge we made, and that, your lordship, was stayed, your lordship, by this order. And subsequently, your lordship, the.
What were the decisions you have cited in, that is in respect of second substantial question of law?
There, your lordship, was how will you apply the principle of restitution in such issues? What happens, your lordship, is subsequently the single judge, your lordship, took a view against the SSC, saying that NCCD is indeed payable. The appeal was filed at the division bench. Division bench also, your lordship, took the view. Few other matters, your lordship, are pending in the Dharwad bench. That's a different point. Here, this petitioner has not challenged the division bench order. So once the single judge, your lordship, took a view against the SSC, the entire duty was calculated and paid. So for the period when this stay order was passed, till the time when the single judge, your lordship, took a view against the SSC, can it be said that there is a non-payment of duty because of a failure of an SSC?
No, but there was only interim order.
Interim order saying, your lordship, that it shall not be levied or collected. It also prevented me, your lordship, from collecting the tax also. Therefore, your lordship.
Identical question.
More or less, your lordship.
Identical question.
More or less, your lordship. Page 8, your lordship. At page 16, para 29 and 30, your lordship. There are 28, 29 and 30. I'll just read those paras.
However,
when it comes to the levy of interest, the impugned judgment held that there can be no levy of interest as there is no substantive statutory provisions for the same. The assessee succeeded on this point and the state has not filed an appeal. Therefore, the finding qua interest having become final cannot be interfered with us.
That is a final judgment.
Next year. However, Shri S. Ganesh, learned senior advocate appearing for the revenue, has argued before us that as a matter of restitution, interest must be granted in favor of the revenue for the period for which stay orders have been obtained in writ petitions filed in 14 and 15. This court has held that if a party ultimately succeeds, it must be put back in the same position as if no such stay orders have been passed. And for this purpose, he referred to and relied upon State of Rajasthan versus JK Synthetics and Navbharat Ferroalloys. Para 30, it will be noticed on a reading of para 23 of Navbharat Ferroalloys that ultimately restitution is not a matter of right, but a matter of.
If you have obtained the stay,
This also, Your Lordship, was a case where the assessee had obtained the
now
stay.
there the final judgment itself ran in his favor.
Now, here, Your Lordship, in this case also, Your Lordship, the final judgment was against the assessee.
Against the assessee?
Yes, it was against the assessee, and thereafter, Your Lordship.
Where is that observation? Correct.
In fact, my lords will kindly see para 27 itself, Your Lordship. Since we have found that the plea of discrimination must fail on the aforesaid grounds, no question of reading down the provisions would then arise.
How? Anyway, you take notice, we are not convinced of that proposition because you have obtained stay. If the other side has obtained stay, then we can understand. For example, a doctrine of lapse under section 11A of Old Land Acquisition Act, etc., where there is a stay, then that period is excluded to the disadvantage of the person who got the stay. So if you have obtained the stay and ultimately you fail, that amounts to granting relief to you,
No,
which otherwise could have not have been granted.
I would have definitely, Your Lordship, argued on that point, but what happens, Your Lordship, is that would be a factor for the purpose of principle. That is the tax. Tax, Your Lordship, I cannot argue that I have got a stay and therefore I would not be in a position to pay. That automatically is there. Interest, Your Lordship, is a point which goes back to the date for the purpose of principle. For the purpose of interest, Your Lordship, that is why I was pointing out the Supreme Court, where Supreme Court says, yes, you ultimately leave it to the discretion of the court to decide whether interest is payable at all or not. That's why we say it's not a matter of right. This, Your Lordship, we're not claiming it as a matter of right. But in the peculiar circumstances of the case, where, Your Lordship, the stay order is suspense the levy and collection.
Correct.
Then, Your Lordship, the interest would be a matter of discretion of the court.
This principle very difficult to understand.
That, I'm only relying on the decision
No,
of the.
that may not come to your aid at all. Because levy of interest on the delayed payment of the tax is an inevitable consequence of delay. There is no discretion to disobey the mandate of the legislature.
I completely agree, Your Lordship.
If
I'm
you
not
are
on that
liable to
point
pay
at all.
tax, and which you were found liable to be when the final judgment came, all that relief that has been given to you is subject matter of restitution, doctrine of restitution.
Yes, Your Lord. Therefore, suspends the very levy, suspends the very collection. And the fact that the party is prohibited from even collecting the principal amount. It can't be, Your Lordship, that my lords will give us a stay, we can collect the tax from. That's not explained, Your Lordship. And those are all decisions, Your Lordship, which Justice explained, Your Lordship. And those are all decisions, Your Lordship, which Justice Nariman looks into in this Indian Oil Corporation, looks into every decision and says ultimately it is the discretion.
In fact,
of the.
B.L. Hansaria, he has written a very good commentary on writ jurisdiction published by Indian Law Institute. He has treated it in a chapter. When interim order is obtained, final judgment goes against the party. What should happen to the interim or
Period.
A separate chapter is dedicated. His
And
son has revised that book.
Okay.
Yes.
Scene number 13, maybe Raviraj.
Yes, Ravi.
No, transfer pricing matter, my lord. Page
Issue,
number 9.
issue emergent notice. Appeal is admitted on the following substantial questions of law. Correct, note-
1 to
note on
4.
actual. 1 to 4. Not on actual. Yes.
Scene number 14, maybe Raviraj.
My lord, the respondent in this case is Bangalore Metro Rail Corporation. My lord, idle funds were deposited and interest was earned out of it. And also there was another income, my lord, receipts from, my lord, tender issuance. So on the first issue, my lord, we have raised two questions of law. Page number, my lord, 8. This honorable,
by a coordinate bench of this court in
in the case of the SSC, my lord. For the
Fertilizers
previous year.
Limited versus CIT.
Well, in the case of the same respondent,
In the case
for the
of,
previous year.
in the case of same respondent for the previous, same respondent assessee for the previous assessment year in favor of the assessee. Wide. Commissioner of Income Tax versus Bangalore Metro Rail Corporation Limited, 2022, 135 taxman.com, 268 Kar. Therefore, that question does not arise in this case. Okay. However, the following substantial question of law, which is the second question framed in the appeal, does arise. First up, appeal is admitted. Issue emergent notice.
Seal number 15.
Lordship had heard this matter in part.
How's
It's about the foreign trade policy where we have a scheme called tariff rate quota.
Is Krishna Kumar our judgment?
Days delay is also condoned in similar circumstances. Days delay is also condoned in similar circumstances.
I issue emergent notice, interim order as prayed for. And 2013 Act.
Seal number 18. Bharat Gowda.
For the petitioner in this case, my lords.
Yes, brother.
For the petitioner in this case, my lords, agreed by the judgment.
Agreed or aggrieved?
Aggrieved, my lord. Wherein I have been acquitted. Been acquitted, my lords. The judgment clearly finds at page number 51, my lords. 51. Whether the prosecution proves behind all reasonable doubt that the accused, without there being any right, title or interest over the reserve forest, measuring 1 acre 20 kuntas in survey number 241 has encroached the land. The point number 1 has been answered in negative, my lords. I have not encroached. The prosecution has failed to prove that I have encroached the said land. I have been
that binds the government.
My lords.
How?
My lord,
finding recorded by a
complaint, my lords. East land is complaint, my lords. East land is adjacent to the said land, and it is clearly mentioned. And moreover, my lords, for acquiring the said land at page number 28 and 29, they have given Google Earth photo, and at 29 they have given one photo. There are no 65B certificate to prove this genuinity of this paper, my lords. At page number 28 and 29, my lords. Such being the case, I am acquitted. Yet an order has been passed to take the possession of the acquired land.
Correct.
My lords.
You may be acquitted of the offense.
Yes, my lords.
But in civil law.
Yes, my lords.
You will be liable. And hold my
Page number 50, my lord, paragraph 9, my lord.
50.
Yes, my lord. 50. Per contra, it will start, my lord. 9, my lord. Para 9. Judgment.
My lords, there on the learned counsel appear. May I read? Page number 50.
57. Per contra, the learned counsel appearing for the accused vehemently argued and contended that accused does not encroach the reserve forest land as
your title to this. Where is your land? Adjoining land.
In Ataneksha itself, they have mentioned, my lords.
Adjoining land.
Yes, it's my lords.
What is the extent of that land?
My lords, that extent is one